What's going on, crypto people? It's the Crypto Sea with another day in the life, in the crazy life of digital assets. Breaking news: the motion to strike fair notice defense from the SEC has been denied. What? I think this is bigger than a body blow, guys. Because it's a haymaker in the SEC versus Ripple case. What say you? Let me know in the chat. Let me know in the comments what you think about that. All right, guys, we got to get into this. This is where I took you with the daily news and around 0. Wow, that is crazy. Here it is here. Shout out to James K. Violent for sharing that. Jimmy James, we appreciate you, bro. Once again, another huge win for Ripple. This might help set up a settlement in favor of Ripple. Yeah, clarity is coming soon, says RippleXRP. Breaking motion to strike the fair notice defense is denied. What? What? Stuart Otterelli spoke to it a little bit. Today's order makes it clear there's a serious question whether the SEC ever provided Ripple with fair notice that its distribution of XRP since 2013 would ever be prohibited under the security laws. Serious question as to whether the SEC ever provided Ripple with fair notice that its distribution of XRP since 2013 would ever be prohibited under the securities law. Stuart Alterati says, good to see Judge rejecting the SEC's attempt to prevent Ripple from pursuing its fair notice defense. It's even more imperative that the sun sets on the SEC's regulation by enforcement approach. And that is coming as well. Wow, that is absolutely crazy news. Now, look, Ripple still has to defend itself in court, but the fact that the George Torres said, no, we're not going to strike that is absolutely outstanding. And in the defense of it is easily done. I'm not a lawyer, but I know that that is an easily done thing here. If I did this full screen, what would happen? Let's see. It's not bad. So here it is right here. United States District Court, Southern District of New York, Securities and Exchange Commission against Ripple Labs, Brad Garlinghouse and Chris Larson. I'm not going to go over all of this. There's a background. The following facts are taken from Ripple's answer and are presumed to be true solely for the purpose of considering the motion to strike. It talks about Ripple when it was founded, blah, blah, blah. In February, October 2012, at Ripple's request, a law firm provided 2 legal memoranda. I think this is huge because this is what Ripple has put in, and the judge has this. In February and October of 2012, at Ripple's request, a law firm provided 2 legal memoranda assessing the potential risk involved with Ripple's then proposed business plans, including risks related to banking and money transmission laws, security laws, commodities laws, gambling, consumer protection laws, copyright, criminal laws, and tax laws. Ripple has sold XRP in exchange for fiat or other currencies. To effectuate those sales, Ripple worked with third-party companies known as market makers that buy and sell XRP on Ledger and on exchanges through blind bid and ask transactions. At times, Ripple has included on its website a list of third-party digital asset exchanges that listed XRP. Ripple concedes that Ripple employees at times observed the trading price and volume of XRP. Ripple also admits that proceeds from Ripple's sales of XRP were used to support Ripple's operation, but maintains that its sales of XRP consistently constituted a small portion of XRP trading volume. In addition to selling XRP, Ripple has also made certain payments in XRP as a virtual currency, substituting for fiat. Ripple claims that it has not sold XRP as an investment. Answer: preliminary statement, XRP holders do not acquire any claim to the assets of Ripple, hold any ownership interest in Ripple, or have any entitlement to share in Ripple's future profits. Ripple, the company, did not hold an initial coin offering or contract to sell future tokens as a way to raise money to build an ecosystem or promise profits to any XRP holder. Ripple also has no relationship with the majority of XRP holders, nearly all of whom purchase XRP from third parties on the open market. Moreover, Ripple has no obligations to any counterparty to expend efforts on their behalf and does not pool proceeds of XRP sales in a common enterprise. Ripple has its own equity shareholders who purchase shares in traditional venture capital funding rounds and who did contribute to capital to fund Ripple's operations, do have a claim on its future profits and obtain their shares through a lawful and unchallenged exempt private offering. Ripple claims that if it ceased to function tomorrow, XRP would continue to survive and trade in its fully developed ecosystem. But, right, so all of this stuff here, Ripple states that it's worked to develop products that utilize XRP to allow financial institutions to effect currency transfers. One of those products is on-demand liquidity, which is intended to affect cross-border payments. Ripple asserts that it has made certain payments in XRP as a virtual currency in connection with ODL in accordance with standard market practices in connection with new products and market, blah, blah, blah. I'm not going to read all of that, right? So it says here, before the SEC filed a complaint in this action, XRP was listed on over 200 exchanges. Billions of dollars of XRP was bought and sold each month. Numerous market makers engaged in daily XRP transactions. Ripple's ODL product was used by many customers, and XRP was used in third-party products, many of which were developed independently of Ripple. So this is the analysis here. Under federal rule of civil procedure, a court may strike a pleading any insufficient defense. Motions to strike an affirmative defense are disfavored and should generally not be granted. In ruling on such a motion, courts deem the non-moving party's well-pleaded facts to be admitted, draw all reasonable inferences in the pleader's favor, and resolve all doubts in favor of denying the motion to strike. To succeed on a motion to strike an affirmative defense, the SEC must show, number one, there is no question of fact which might allow the defense to succeed. There is no question of law which might allow the defense to succeed. And number three, the plaintiff would be prejudiced by the inclusion of the defenses. Let me say those again. Number one, there is no question of fact which might allow the defense to succeed. Number two, where is that? There is no question of defense. All right, so number one, there is no question of fact which might allow the defense to succeed. Number two, there is no question of law which might allow the defense to succeed. And number three, the plaintiff should be prejudiced. The plaintiff would be prejudiced by inclusion of the defense. With respect to the first factor, the plausibility standard of Twombly applies to determining the sufficiency of all pleadings, including the pleading of an affirmative defense. Therefore, the pleading party, here Ripple, must support its defenses with enough factual allegations to make them plausible. That said, courts generally apply a lower plausibility threshold when evaluating motions to strike affirmative defenses as opposed to motions to dismiss, because the pleader has less time to gather facts and craft a response. As to the second factor, an affirmative defense is improper and should be stricken if it is a legally insufficient basis for precluding a plaintiff from prevailing on his claims. Furthermore, in considering the third factor, courts generally look to when the defense was presented. A factually sufficient and legally valid defense should always be allowed if timely filed, even if it will prejudice the plaintiff by expanding the scopes of the litigation. Because the defendant with such a defense is entitled to a full opportunity to assert it and have it educated before a plaintiff may impose liability. The fundamental principle in our legal system is that laws which regulate persons or entities must give fair notice of conduct that is forbidden or required. This clarity requirement is essential to the protections provided by the Due Process Clause of the Fifth Amendment and requires the invalidation of laws that are impermissibly vague. I'm not going to continue reading on here. As an affirmative defense, Ripple pleads that it lacked and the SEC failed to provide fair notice that its conduct was in violation of law and contravention of Ripple's due process rights. Answer: affirmative defense. The SEC argues that the court should strike this defense at the pleading stage because it is legally insufficient defense on which Ripple cannot prevail as a matter of law. The SEC also contends that it would be prejudiced by Ripple's defense because the defense would lead Ripple to seek intrusive discovery. After considering the SEC's argument, the court holds that the SEC has not met its burden of showing that Ripple's fair notice defense should be stricken at this time. The parties agree that Ripple is not bringing a facial challenge to the statute, CSSC, or because the court is reviewing as an applied challenge, the court shall consider the application of the challenge statute to the person. A lot of lawyer stuff here. I'm sure John Deaton and Jeremy Hogan at Legal Briefs will go over this without question because they'll find some stuff in here that'll be more applicable and make us better understand it. All right. None of the cases cited by the SEC support a contrary result. In some cases, the courts assessing a fair notice defense did so when ruling on a motion to dismiss, where the court was obligated to draw presumptions and references. None of these. This is not a good look for the SEC at all. Moreover, the SEC has not shown that it will suffer under prejudice as a result of the continuation of Ripple's fair notice defense. An increase in the time, expense, and complexity of a trial may constitute sufficient prejudice to warrant granting a plaintiff's motion to strike. An increase in time. However, a sufficiently pleaded defense should always be allowed if timely filed, even if it will prejudice the SEC by expanding the scope of litigation. The SEC does not contend that Ripple's affirmative defense is untimely, and the court shall not conclude at this early stage of the case that Ripple's defense is invalid. Accordingly, the SEC's motion to strike Ripple's fair notice affirmative defense is denied. For the foregoing reasons, the SEC's motion is denied. Ha ha ha. The clerk of the court is directed to terminate the motion. Ha ha. I freaking love it. Love it. I can't wait to see if Jeremy Hogan, I think John Deaton had a little something to say on about this as well. Where is this? John Deaton said something, and I might have gotten rid of it. I probably did. He just said that he put it on crypto law as well. But I think this is something to them to share. John shared. He caught on to this from Monica Long. Very, very true. Monica Long put this out 3 hours ago. USDC and USDT are live on the XRP ledger. The ledger, the XRP ledger that uses XRP, burns it for transactions. The two largest ERC20 stablecoins are available on the XRPL DEX for the first time. Opens up a world of possibility with payments and more. I got to figure out how to get on this freaking ledger and do it the right way. This is from GateHub. GateHub is doing it, right? GateHub, the day has come. You can now trade or make deposits on Tether, USDC, Wrapped XRP, and Gala. Find out which of them you can trade for free for the next 90 days. What? I got to figure out what's going on with this GateHub thing and how to use it. I don't know how to use it. I don't know how to use it. I really don't. I mean, I kind of do, but I really don't. I mean, I think when I'm using the Zum wallet, I'm doing stuff on the XRPL DEX, but I don't know. I don't pretend to know it. I really don't. But what's the name responded to this? You are now able to transfer the stablecoins Tether and USDC on and off GateHub for 24/7, 365 fiat denominated transfer of value. Hashtag RippleXRP gives you a taste of interoperability between Ethereum swap-based DeFi and the XRP Ledger, XRP Ledger's order book-based decentralized exchange. For the SEC is RippleXRP a security? I freaking love it. There it is, guys. That is absolutely exciting. Does Ripple still have to defend themselves? Absolutely. But it is very, very clear. And you can check the market because the market XRP is up at least 6%. Last I checked on this news, it was at 72 cents when I did the video today. And after this news, it has moved up very, very close to 80 cents. Yeah, 79.6 cents. So absolutely outstanding news. And I think once this kind of gets out to the other nations, especially Asia, it's going to be even bigger. So there's 79.6 cents is absolutely outstanding. And again, I can't wait for the likes of John Deaton and Legal Briefs, Jeremy Hogan and his wife, to talk about this, because I think to give us some greater insight. I think it's going to be absolutely outstanding. There it is, guys. The motion to strike the fair notice defense is denied. I freaking love it. I wonder if Brad Garlinghouse has said anything about this. Let's check and see real quick if Brad has said anything about this, because this is I'm telling you, this is a haymaker. This is a haymaker, because that was the biggest thing, in my opinion. Oh, there it is right there. If you weren't paying attention, then you should by now. You should be now. Huge win for Ripple today. And while we would have preferred the cases against Chris and me to end now, the SEC must now prove its claims. We are confident that ultimately all of them will be dismissed. Let's go. Let's go. This is what I'm talking about. Let's freaking go. All right, guys, look, I'm going to end this video like I do all my videos and remind you guys of this, that old money doesn't want you to win. They don't want us to win. They would rather that we remain a cog in their perpetual wheel of trading our time for dollars. They don't want us to play in the same playground that they play in, where we allow our money to work for us. This is our chance to win, guys. The digital asset space is our chance to win. We're in the midst of the greatest transfer of wealth in the history of man. Are you participating, or are you standing on the sidelines? Here's what I do know, that the battle for you has already been fought, and the victory is yours. Go get it. I'll talk to you soon, guys. See ya. Bye.